Good morning, and thank you for joining me on the path to liberty. It's Wednesday, January 6th, 2021. And if you're a regular listener or viewer of the show, or you've followed our work at the TAC for a long time, you won't be surprised to hear me say that the most effective, maybe the only way to defeat unconstitutional federal programs is to follow James Madison's advice, many others, James Iredell, Thomas Jefferson, others, but let's talk about James Madison and his advice in Federalist 46 to use a refusal to cooperate with officers of the Union. And you may also be aware that the Supreme Court, surprisingly, which I'm not a fan of as a final say, that's not the original legal meaning of the Constitution, that the Supreme Court can tell us what the Constitution means until it changes its mind. It's the other way around. The Constitution means what the Constitution means, no matter what the Supreme Court has to say, but that's a side note. So you might be aware that the Supreme Court has actually done its job and validated James Madison's advice over and over and over for almost 2 centuries now in something called the Anti-Commandeering doctrine. And I've covered that in various forms on this show, but on this episode, I want to cover the top 6 questions we get about anti-commandeering, including a brief overview of the doctrine, what it is, where it comes from, the strategy, how it's been implemented, and some other questions that we've got. But first of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific Time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage has everything you need to follow this program. All of the archives for 2.5 years. On individual episodes like this one today, I'm going to include links to a bunch of articles for you to read and learn more on your own time. I'm really just scratching the surface in this, and I hope you're interested in getting more information. So you're going to find each episode have tons of reference links. You'll also find all the different platforms we're on. We're on a ton of them. We live stream on some of the mainstream ones like YouTube and Facebook, and we also have Twitch and Twitter. We're also on DLive. Hopefully we'll get live streaming capability on some of the archive platforms, primarily library.tv. It's decentralized and censorship resistant. It's my personal favorite platform for the future to protect our ability to communicate with each other, library, LBRY.TV. They also have another project called Odyssey, ODYSEE.com. It's the same content, but web-based version. So library, there's Brighteon, BitChute, and then, of course, the podcast editions, and I appreciate all the reviews that have been coming in on Apple Podcasts. That helps tell Apple to show the podcast to more people, so on Apple, Spotify, Stitcher, Podbean, and elsewhere. And you can even find our membership program for as little as $2 a month. You can support us in our work to stand for the Constitution and liberty. All that and more over at the show homepage, 10thamendmentcenter.com/path to liberty. Again, 10thamendmentcenter.com/path to liberty. And while we take another minute or so to allow people to get notifications on those mainstream platforms, it tends to be a little slow for people to get notifications and join us on a live stream. I want to say hello to everyone out in the live chat, or as many as I can scroll through. Marcus, it was cool of him to stop by over on YouTube and say hello. He said he was not going to be able to watch the live show, but we'll check back later. Thank you so much, Marcus. Blue North Wind, always good to see you. Funky in Minneapolis. Bob Landry down in San Antonio. Patricia Dance, MRGF 78. Clay Kent says hello. Tim Martin in Casa Grande, Arizona. Hello to Justin Morrison. Dixie Strong in Alabama. Salt Lakers. Dan Reed points out that the sound works. I think we got the problem resolved that I screwed up. I just had some setup issues that finally caught up with me on Monday, and we had a crash during the live stream, but it seems to be working. If it does ever crash, generally it's not the new world order taking us down. Most of the time it's my own error. I would say 99 times out of 100 when something goes wrong on the stream, it's my error. So hopefully you guys stick around if we ever have problems, and I'll get things uploaded later. Rob Harris, Jeff Stewart, good to see you, buddy. Wyatt, Adrian Smith, Matt Beckelmeyer, and everyone else. I appreciate you all being here. I apologize if I missed anybody, but let's get right to it. I will check the comments a little bit later on, especially in the archives. Please do comment later. That also helps trigger the algorithm, and it gives me a lot of great ideas for future shows. So, anti-commandeering doctrine. Let's start out with the first question. What is this thing? And this is from an article we published maybe yesterday by Mike Meharry, sometime in the last couple of days. And he puts it this way: anti-commandeering is a long-standing Supreme Court doctrine. In a nutshell, the doctrine prohibits the federal government from commandeering state personnel or resources for federal purposes. It sounds like piracy, right? I love the name because, if you're going to commandeer a ship, that really gives you an idea that someone is forcefully boarding. They're using the threat of violence to say, you're going to give us your goods, your manpower, your resources, etc., to do what we want. And that's what the federal government has always tried to do with the states, tried to enlist the states to enforce federal programs. And one just quick aside, sometimes, well, it depends on what side of the political spectrum. You've mainstream left and right, they always seem to find ways where they like it when the federal government does this, and then other ways where they don't. But the fact of the matter is, when you like it, you're setting the precedent. You're setting the precedent for them to do it on other things. So we want to reject it all around, all the time. So in effect, Mike writes, the federal government is constitutionally prohibited from requiring states to use their personnel or resources to enforce federal laws or implement federal regulatory programs. For instance, a local sheriff, while they can't necessarily physically impede federal agents from enforcing a federal gun law in this current legal status quo that I've covered elsewhere, but under anti-commandeering, the ATF cannot force or require a sheriff's office to participate in the enforcement effort. And we've seen this used throughout history. So what is it? Where does it come from? Question number 2, where does this come from? And I don't think most legal commentators have actually connected the dots on this. I saw it once in a 2014 paper from some legal scholar, but I think we're a little bit more advanced on seeing the connection between the original legal meaning of the Constitution, the ratification debates, the Federalists and Anti-Federalists, and even the papers and the resolutions and things leading up to the Revolution, the Articles of Confederation, the entire big picture. And a lot of people think the legal people who only study from 1803, Marbury and Madison and forward, they never study the actual founding. They never study the lead up to the Revolution. They don't study that history. So they think that anti-commandeering is just an invention of the Supreme Court. And even if you could make that case, it has its lineage all the way back to the founder of the Constitution, or the father of the Constitution, the father of the Constitution, so-called. There's also James Wilson, Gouverneur Morris, and others. But Madison in Federalist 46, he offered a number of actions, and Mike puts it this way, but most significantly, he suggested, quote, a refusal to cooperate with officers of the Union. This was in Federalist 46, where James Madison was arguing against people who were saying, in New York primarily, they were saying, well, we should really worry about this. The federal government's going to be too powerful. And he went on to show, like, look, the way the system is set up, the states, the people, they have means that are powerful and at hand. And he offered 4 steps on how to undermine and defeat any federal program, whether it was constitutional and just bad policy or unconstitutional and never should have been done in the first place, not even authorized in the first place. One of those 4 was a refusal to cooperate with officers of the Union, whether it's by states not participating in enforcement or individuals just not, it was obsequious was the word he used, disobedient in essence. I covered this all in much more detail just before Christmas this last year. James Madison, How to Defeat Federal Programs. If you did not check out that episode, I will link to that in the show notes at 10thamendmentcenter.com/path to liberty. I think it is actually, even, it's a seasonal one, but it actually might be the most important thing for us going forward in the years ahead, to actually understand how the founders, now Madison, of course, he wasn't just making this up out of nowhere, he was also understanding his experience and the experience of the revolutionaries, the experience against the Stamp Act, the Townsend Acts, the Intolerable Acts, the Coercive Acts, and how they actually defeated the largest empire in the history of the world before the war commenced. As John Adams put it in a letter to Hezekiah Niles in 1818, he says the revolution was a change in how they approached stuff. And that happened over a period of decades. So please check out that episode. I'm going to find a way to feature that on our website because it's so important going forward. We're going to have to really, and I've been saying this for years, we have to follow the advice of the founders and stop going to the federal government to limit the power of the federal government. Anyways, so the anti-commandeering doctrine has its lineage back to Federalist 46. The next question that we get, number 3, is, does this actually work? Are you just talking trash? Hey, Bolden, this is really interesting philosophical stuff. But what'll happen? And that's actually more important in my mind. More important than anything, because even though we want to talk and educate and learn and read and watch and listen, when you get down to it, the only reason to go through all of this effort, all this learning and research, the only reason for it is so we have a practical tool in front of us to actually advance liberty, rather than just dream about it. And so Mike Maharrey covers this as well briefly. Will this strategy work? And the answer is an emphatic yes. I would say it really is the only way that we can get things done. It is the only thing. It has worked throughout history. It has worked in modern time. And Mike puts it this way, and even more so today than at the time. The federal government relies heavily on state cooperation to implement and enforce almost all its laws, regulations, and acts. Most of them shouldn't exist in the first place. But the federal government doesn't have the money, the manpower, or resources, even with the amount of printing that it does not have the resources to get done what it wants to get done. And the way that it can sneak by and make you look at your state as being the bad guy, well, your state, wherever you live, the states are awful as well. But what they're doing is they're basically acting as they're stormtroopers for the empire. And if the stormtroopers stop participating, then, the Death Star doesn't have as much enforcement capability. So Mike says by simply withdrawing this necessary cooperation, as James Madison advised, states and localities can nullify many federal actions in practice and effect. And he points out that the National Governors Association also said this. I mean, not in so many words, but we know what's happening here. In one of these fake shutdowns, I mean, they're never a real shutdown, of course, but one of these things where they're scaring us that the world's going to come to an end because they're not spending more than every government on earth on government. I mean, the fact that the U.S. government spends about 8 times the amount of the Chinese government, the communist government in China. I mean, this is embarrassing. This is shameful that people would ever think that someone in Washington, D.C. is going to defeat socialism while being the largest socialist on the planet. And that comes on all ends of the spectrum there. But the National Governors Association during the 2013 so-called shutdown was alarmed about it. Why? Because this is how they put it. States are partners with the federal government on most federal programs. And here's their dirty little secret. Partnerships don't work too well when half the team quits. Plain and simple. Now, interestingly enough, Alexander Hamilton, of all people, validated this strategy. He wasn't doing so on purpose, I don't think. But in Federalist number 16, he was actually complaining about the idea that states might be able to get willy-nilly. He's always arguing for more centralized power. Unless he's trying to convince people to do something, then he'll make the proper argument and flip-flop later on. But anyways, in Federalist 16, he put it this way, and hopefully it'll make sense when I read it. He says, if the interposition of the state legislatures be necessary to give effect to a measure of the Union, they have only not to act or to act evasively, and the measure is defeated. He recognized even at that point when the government was going to be so tiny in comparison to today, that if you actually would rely on the states, you've actually given them so much power that all they have to do is just sit on their hands or do something evasively, and you can defeat that. Now, of course, he was looking at that as a potential flaw. He was concerned about it. He wanted to make sure that the federal government or the central government had more power to coerce states and whatever in that situation. You could read Federalist 16 on your own. I will link to Mike Maharrey's article about it and the original document. But this is something that he stumbled on. This is an actual truth. Now, we have an example of how this plays out today. And back to Mike's article, he says, consider the 36 states that have legalized cannabis despite federal prohibition. I mean, we all think that's just been easy peasy, but for those of us who've grown up through this, I moved to Southern California in 1995, Prop 215, I forget the name of it. Prop 215 was passed in 96. And the federal government today still makes this plant illegal at every level, but yet we have 36 states somehow defying them. Well, what they're doing is they're refusing to cooperate. People, localities, and state and local governments, they're all in some way, and it's actually very narrow in most places, are refusing to cooperate, and they're getting away with it. We're seeing it play out before our very eyes. Mike points out that our research, at least when we've gone through the amount of money it costs the DEA to do a bust, a raid, an investigation, and a prosecution, our figures tell us that it would take about 40% of the DEA's yearly budget just to investigate and raid all the dispensaries in Los Angeles. At the time we did this, maybe there was like 1,200. So the number's probably a little bit lower here because the locals haven't been too freedom-oriented. But, well, that's not to be expected, of course. And that's just a single city in a single state. So 40% just for one city. That doesn't even include the cost of prosecution. The lesson that we learn, Mike says the feds lack the resources to enforce this prohibition without state and local assistance. Period. And the same is true for virtually every federal action. The National Governors Association knows this. Everyone should know that most federal programs rely on state assistance. Most environmental regulations, the EPA isn't going out and doing most of the regulations. They're actually contacting state EPAs, basically, to enforce and implement federal regulatory programs. And they hand out cash, of course. But the states don't actually have to do that. And Mike says the same is true for virtually every federal action, from gun control to Obamacare. I mean, if you think about it, they couldn't even run a website when they got this thing going. They could barely get that thing moving. To Obamacare, to FDA mandates. The federal government depends on the states, and the states don't have to cooperate. And we might even see things like a CDC mandate. Well, we already are starting to see that, but we may see things like that in the future. But if the states don't participate, who's going to go out and do the enforcement? In other words, no one. So this absolutely does work. It has worked. It has worked throughout history. I've covered how northern states nullified the Federal Fugitive Slave Act of 1850 a number of times on this show. I covered it on the Tom Woods podcast as well. This is very effective, and we need to follow what's been working on more and more issues. Now, some people will say, well, this is a question we hear pretty often, like, why is this even up to this? How are states even answering this question? How can we have states determine whether or not a federal action is constitutional or not? Isn't that the job of the Supreme Court? And that opens up another line of conversation that I'm not going to get into. But the short answer, as Mike puts it, it doesn't even matter. You don't even have to think about constitutionality when using noncompliance through the anti-commandeering doctrine. Madison himself told us that this could be used for what were called warrantable, that is constitutional, federal acts that you don't like, you think are bad policy, or unwarrantable, stuff that they shouldn't have done in the first place. And that's what Mike is saying here. He says constitutionality is not even part of the equation. It's a manpower question. The anti-commandeering doctrine does not depend on a finding of constitutionality. States can refuse to provide personnel or resources for any federal activity, regardless of its constitutionality. The utilization of state resources, funds, and personnel are totally at the discretion of the state government itself, and in many situations, just the local government. So if a local government does not want to participate in, for example, the Pentagon's 1033 grant program, which militarizes local police, they can just say, you know what? We're out. We're not going to do this. And we're starting to see more and more of that happen over time. They can also do that, for example, on the JAG grant program, joint task forces, surveillance programs, and the like, providing water to the NSA data center in Bluffdale, Utah, for example, things like that. The next question is, well, I also wanted to mention this idea of they don't even have to do anything ever. This was actually covered in a Supreme Court case, and I'll get to the Supreme Court cases in just a moment. In Murphy versus NCAA, so we're not just talking about deep history. This is 2018. This is the most recent anti-commandeering case to hit the Supreme Court. And again, I'm not the type of person that says, well, we have to have validation from the Supreme Court, because that undermines the whole idea that, we're going to exercise our rights whether the government wants us to or not. Nullification, resistance, anti-commandeering is not based on what the Supreme Court tells us. The reason we like citing it when they're right is because it makes it a lot easier to make the case to the general public and to state legislatures, because they've been propagandized since birth, like all of us. That is, The government tells us what it's going to do. Every federal act is supreme, and they're supreme until the Supreme Court tells us otherwise. So the Supreme Court has told us otherwise over and over and over. And in 2018, the most recent one, the court held that Congress can't take any action that, quote, dictates what a state legislature may and may not do, even when the state action conflicts with federal law. So even the Supreme Court has held that Congress cannot go to a state and say, you got to do this or you got to stop doing this, no matter what. And here's how Samuel Alito put it. He said, a more direct affront to state sovereignty is not easy to imagine. Now, I could cover all the cases in some detail, and that's question number 5. What are those Supreme Court cases? Which Supreme Court cases support the anti-commandeering doctrine? That's how Mike put it in his article. I just want to briefly point out that the doctrine rests on 5 landmark cases. There might be another one in there that we haven't gotten into some detail yet, but there are 5 major ones, and it starts in 1842, a case known as Prigg versus Pennsylvania. And this is great for the people that tell us that, you know, if you just want to opt out of the federal government, you must be a racist. Well, this is just lying bull. I mean, it always has been, but it's pretty easy to throw this in their face, because Prigg versus Pennsylvania, 1842, Justice Joseph Story, and I'm reading from Harry's article, which I will link in the show notes, held that the federal government could not force states to implement or carry out the Federal Fugitive Slave Act of 1793. This was a pro-slavery catching act, so escaped alleged slaves. The feds had a federal law to actually capture them and return them to owners, so-called owners in the South. And the Supreme Court was like, well, you know, Pennsylvania is not participating, and there's nothing in the Constitution that authorizes the federal government to require them to participate. Now, if the feds are going to try to enforce it, he didn't actually strike down the Fugitive Slave Act, which I think is just repugnant to any part of anyone having good morality, of course, but man, that's a tough one. Anyways, he didn't strike it down, but he said, look, clearly the federal government there's nothing delegated to the federal government in the Constitution that can require states to help the federal government do what it wants to do. So he said that it was a federal law, and the federal government ultimately had to enforce it. If you're really interested in geeking out on the cases, and a number of people have been asking about this, I did an entire episode going through those cases in early 2019. This was just a year after that most recent landmark case. 1842 is Prigg versus Pennsylvania. 1992 is New York versus U.S. 1997 is Prince versus U.S. That's the Sheriff Mack case. 2012 is NFIB versus Sebelius. That's the famous Obamacare case. And then 2018. Anti-Commandeering, the legal basis for refusing to cooperate. I went through those cases in some detail. I'll link to that in the show notes. And then number 6, well, can't they just withhold federal funding? Okay, so you've made the case that you can do this, you can get away with it, it actually works, you don't have to worry about determining constitutionality, the Supreme Court has actually backed this up, but won't the feds just say, okay, you aren't participating in enforcement of this federal gun control measure, so now we're going to take away all your highway funding? And a lot of people think this is going to happen, but a lot of people are absolutely wrong. Mike only goes over this very briefly, but he says, in simple terms, the federal government cannot use funding to coerce states to take a desired action. There is some gray area. They can do what they call encourage states, and they can also encourage states with funding that's related to an action that a state refuses to take, but it still has some limitations and caveats. For example, Congress can't cut education funding to punish a state for not cooperating with cannabis prohibition. It has to be something. There was a case on this that I covered in an episode just last month. Can feds simply yank funding to punish states? And I covered a case, South Dakota versus Doyle in 1987, that a lot of people who actually believe that the feds can just withhold all highway funding, they think that that case actually supports it, but that's nonsense. Basically, what the court said was, if you didn't agree to the conditions, like you're only going to get this funding if you do these certain things for the federal government. They can do that. They can make that agreement. The state can actually make that determination. Well, if you're going to steal money from people and then divvy it back out, I mean, they don't think of it that way. But if they do actually say, we're going to do this right when the funding starts, then certainly that can happen. But they can't create new conditions down the line. especially if it's unrelated funding. And even if it is related funding, let's say it's like a law enforcement grant and they're saying, well, if you don't start doing facial recognition on everybody to survey everybody in your city or your state, then we're going to withhold all these law enforcement grants that we've been giving you. That might be a positive, but they can't actually do that. Even in that scenario, according to the South Dakota versus Doyle case, they still can't be coercive. And that's what happened in the 2012 Sebelius case. They followed up and said, look, we've already said if you try to coerce them, try to withhold all of their funding, even on a related issue, we're going to strike that down. We're going to say, no, it shouldn't happen. You can't do this. And in South Dakota versus Doyle, they took highway funding because South Dakota didn't want to raise the drinking age. And in that situation, highway funding, they were only authorized to take 5% of highway funds from the first year, 10% after that. So small, they can still do it, but it can't be tons. And there's gray area, and I wish it wasn't a gray area because I don't think they should be doing this anyways. And an income tax, the taxation is theft. It shouldn't be, this whole process shouldn't be happening, but let's think about how it plays out in practice. And in the end, the states don't have to worry about the feds just taking all their funds. Now, they may have to fight that and may have to go to court about it, but it's not going to happen. We don't actually see it happening in practice. Well, those are the top 6 questions we get about strategy, history, the court cases, how it all plays out, etc. I hope you guys found this interesting and educational. More than anything, I hope you learned something out of this. This is something we actually use every single day, especially at this time of year that we call nullification season, when state legislatures will be considering as many as 200, 300, maybe 400 pieces of legislation to undermine, in some ways, in most situations, a narrow part of federal so-called law, but it's primarily using this anti-commandeering doctrine. We're getting more and more actual successes every single year, and I think we might see much more in the years to come. Looking over at the live chat, Salt Lakers has a great one. Absolute power corrupts absolutely. We should absolutely know. And maybe that was in response to pointing out you don't want to support them doing one thing for something you like. That's what George Washington, I cannot stop repeating this, in his farewell address of 1796, even if he pointed out that even if you like the short-term results, let there be no change by usurpation. That is, exercising powers that the federal government isn't authorized to exercise. So even if you say, well, oh my goodness, this is an emergency. Everyone's got an emergency, whether it's healthcare or war or immigration or whatever it may be, there's always an emergency. And so people are willing to turn a blind eye and say the federal government has to come in and save us. Nothing else is working, generally because we're not creative enough to think of it, or we've been propagandized and we think that the federal government is supposed to do these things. But as soon as you do that, Washington said this is the customary weapon by which free governments are destroyed. Fiat currency, that's probably Shane Lackey. I saw somebody say fiat currency is also corrupts absolutely. We have a pretty good one. Some interesting comments from Walter and Clay. And Salt Lakers, the most terrifying words in the English language. I'm here from the government and I'm here to help. Yeah, they're always helping us. They're helping us to financial oblivion, to death in many situations. Anyways, I will take a good look at the chat a little bit later on. If you've got additional questions or thoughts, please do leave them in the archive. That does, or just leave it in the comments section. I read through all of them, primarily on Facebook and YouTube, but I do look at the other platforms, library and elsewhere. And I get tons of ideas for future episodes because of your questions and suggestions. Sometimes they're totally unrelated. You can also email me, team@10thamendmentcenter.com. Make sure to smash the like button if you support the show. Smash that like button. Subscribe, get notifications, reviews on Apple Podcasts and elsewhere. All that stuff triggers the algorithm of the platform you watch or listen on, mostly the mainstream ones, and it tells that platform to show the program to more people. Thank you for helping out. And of course, if you want to put your financial faith behind our work, I see a number of people out there who are really the engine behind what we do. Without the financial support of our members, there's no way we could roll up our sleeves every single day and reach and teach more and more people about the Constitution and liberty. If you want to join them, don't feel any pressure to do so. We're going to continue putting this information out for free. But if you want to help us reach more people, $2 a month is as little as it starts. 10thamendmentcenter.com/members. Again, thank you for being here today. I hope you enjoyed the show. I hope you learned something, and I'll see you next time here on the Path to Liberty.